Everyone, yep. This is in the matter of the people of the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180FC. I have John Glazier appearing on behalf of Mr. Dietos and Allison Arnold appearing on behalf of the people. So this is a date and time set for sentencing. The last time you were here, Mr. Glazier, your client had, after you very thoroughly questioned him on the record, asked to withdraw his motion to withdraw his plea.
That's correct, yeah.
Okay, so, and Mr. Dietos, and you have discussed that further, and
I have. I just would indicate for the record, Your Honor, when I was here the last time, his mother was here, and I had never spoken to her. And she asked me out in the hallway what the motion was and all that type of stuff. And she says, what was my recommendation? And I told her, my recommendation is that he should have had an independent evaluation done all along. She told me that she believed she had talked Christopher into taking this plea and to not withdrawing this plea. But I want to make sure, Christopher, you want to proceed to sentencing.
so Mr. Dietos, can you raise your right hand for me? Do you solemnly swear or to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, Mr. Glazier, you may proceed.
I'm going to ask you this quickly. So when we were here last time, we went over in great detail the plea, the sentencing and all that type of stuff. And you said you wanted to not withdraw your plea, you wanted to proceed with sentencing. Is that still true today?
Correct.
Did your mother have some sort of influence on you in making the original request to take the plea or anything of that sort?
This is all on me. This is my decision.
Right. I'm comfortable with that.
All right. All right, so Ms. Arnold, is there anyone that wishes to speak today?
Not to my knowledge, Your Honor.
Okay. All right, so Mr. Dietos, have you received a copy of the pre-sentence investigation report?
Yes, but I do not have it with me.
You don't need it with you, but you did receive a copy to review, correct?
Correct.
All right, and did you have an opportunity to read and review that and discuss it with Mr. Glazier?
Last week, right?
Yeah.
Last week, yes.
Okay, so I think you actually were back in a room and Mr. Glazier talked to you about it?
Yes.
Okay, and do you feel he answered any questions that you might have had?
Yes.
And you thoroughly understand the pre-sentence report and what it contains?
To my best ability, yes.
Okay. Do you have any further questions about the pre-sentence report?
What she was asking is it accurate? You've read through it.
I went over that probably more than 5 times sitting.
Oh, good.
Is there anything glaringly wrong or anything you noticed that
It was
was?
like striking kind of weird.
Yeah,
No,
Yeah,
no,
you-
no, I mean,
other than recommendations, is there anything you disagree with?
no.
All right, are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes.
Okay. Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, my client says it's accurate.
Ms. Arnold?
Judge, not with the report itself. I did go over the offense variables and
I haven't gotten there yet. so
Oh,
give me
yeah,
just a
okay.
minute. Okay.
I don't know your routine yet.
Okay. Does the pre-sentence report disclose any prior convictions, Mr. Glazier, in which there exists any constitutional defect? I show he has no prior
I
convictions.
don't think he has a criminal history at all.
All right, now we'll go to the guidelines. So I have received today guidelines, a new SIR. So let's see here. So originally, the guidelines I had, let me check this. The original guidelines that came with the pre-sentence report for the child abuse charge, the original sentencing guidelines were 29 to 57 months. And on the homicide manslaughter charge, the guidelines originally computed were 135 to 225.
Just you've got that flipped. The child abuse first degree is the A felony, that's the higher.
Oh, okay. All right, let's see. I wrote it in the wrong place then, probably 29 to 57 on homicide. Yep, and 135 to 225 on the child abuse. Now I received an updated SIR from Ms. Holly today. And on this one, on the homicide manslaughter, the guidelines are calculated to be 19 to 38. And then the guidelines on the child abuse first degree were calculated at 135 to 225. I do have in my file that the prosecutor and the defense attorney at the time before the plea had computed the guidelines to be 135 to 225. So with regard to these guidelines, Mr. Glazier, do you dispute any of the PRVs or OBs?
Your Honor, I want to put a general complaint on the record is what I want to do. I was set and then, excuse me, she turned my phone down in the court. Hold on. I was given this by the probation department about 15 minutes ago and said, well, don't worry about it. It keeps the guidelines the same and it really does, it just changes a few things.
I have time if the three of us want to go back and go over the guidelines real quick.
That's not the point, Your Honor. The point is, if they're gonna do that, I just wish they would give me some notice. I've talked with my client and I said I probably could have adjourned this and come back for a sentencing. We've already adjourned it once for the victim to be here, and that's why we're here today, for the mother of the victim to be here today. I gotta believe that the scoring probably does benefit my client a little bit, although I don't remember what OV7 is or OV7.
I seriously, 5 minutes in the back room, we can go through these guidelines and resolve. I don't want any outstanding issues hanging.
I just should put on record, Your Honor, I asked my client if he wanted to adjourn so I could spend more time on these. And he said, no, he wanted to
Okay,
proceed.
so Ms. Arnold, Mr. Glazier, and Ms. Holly, you guys go that way into the jury room. I'm gonna get my updated sentence and guidelines book, and I will be right back there with you.
All rise.
You can be seated. All right, so we are back on the record. I was able to have a thorough conversation with Mr. Glazier, Ms. Arnold, as well as Ms. Tully from the Michigan Department of Corrections, and we reviewed the changes from the original guidelines to the ones that were provided today. So we reviewed the ones that were scored today, and Mr. Glazier, would you agree at this time that these guidelines are scored correctly?
The new ones, yeah.
Yes.
Yes, yeah.
Okay, very good. So, all right. So we have no one that wants to speak today. So, Mr. Glazier, is there anything you'd like to say on behalf of Mr. Diaz? Other than Ms. Arnold, I'll give you an opportunity at the end, but you did not have a victim there. Mr. Glazier.
Yes, Your Honor. I would just indicate that the guidelines in this case, I tried to make it real clear to my client what the guidelines were. There was a Cobb's plea that this would be within the guidelines. And I gave him these exact guidelines as what it would be, what the guidelines would come out at. So he was aware of what was going on. This is an unfortunate situation, Your Honor. If you read the PSI, you'll look and see that my client, it was a situation where the mother talks about how Christopher does not have a lot of experience with babies. This is his first child. She's been trying to teach him how to care for a baby. She stated she has never seen Christopher become angry when frustrated. It's a situation where he was not even supposed to be watching the baby that day. It was going to be not his mother-in-law, but actually his girlfriend's mother was, and something came up, and so he ended up having to watch this baby on his own, which for a normal person doesn't sound like a big problem. most people can handle a baby. The situation with my client, Your Honor, is he's a 51 IQ, and I don't see where, I think that's referred to in the police report. If not, you can look at the psychological evaluations, and it puts what his IQ is in there. If you run the test that was given to him at that time, that puts him at the level of an imbecile. He's characterized as an imbecile under that IQ test, a score of 51. He doesn't have a lot of control over some of the things he does. You know? He's always had some limited learning abilities and coping abilities and all sorts of things throughout his life. If you want to hear him in detail, his mother's here and she'd be more than happy to explain to you all the problems he's had growing up as a child and as an adult. They've done the best they can to treat him as an average, ordinary child. And that's one of the reasons when he communicates, he talks fairly well. You would never guess that he has these limitations. I was quite surprised when I saw what his IQ came in at. I guess the point is, Your Honor, you can see he's taking medication on page 3. That's where I was reading from before. For his issues, but nobody, the prosecutor, or not the prosecutor, the probation department recommends 15 years to 50, which is within the guidelines. I can't imagine that he wouldn't parole out early, parole out on time. This is not a vicious murder or a vicious child abuse case or anything of that sort. It was a situation where if a jury finds, not that he intentionally, but that he knowingly caused harm to a child, that could be bootstrapped into a first-degree murder, and he'd never get out. He'd be in there for the rest of his life. And he knew, and I think he knows, and I think he understood that he couldn't risk that, and that's why he took this plea. Against my advice, I still would have preferred to have had an independent evaluation. That being said, Your Honor, my client has suffered as big a loss as anybody in this case. Now, granted, it was because of some circumstances that he was responsible for, or at least that he couldn't control, and that's unfortunate. But he's lost his only child, Your Honor. His only child is dead because of the mistake that he made, and that's a hell of a punishment. We would ask the court to go to this screams out to be at the low end of the guidelines. This should be the 11 years, 7 months, or 10 years, 7 months, whatever it comes out as the number of months under the guidelines. That's when he should be eligible for parole. And if for some reason the parole system doesn't parole him out quick, I just can't imagine him spending 50 years in prison for this. For a mistake on his part. It's tragic, not only for the mother, who I guess isn't here today, and for obviously bad for the child. It's bad for everyone, but it's likewise very, very bad for my client, guys. And I'm sure he can barely stand it. I don't have any else.
Mr. Jathos?
Yes,
Is there anything you'd like to say on your own behalf?
I wish Brittany was here so I could apologize to her, but I can see she's not in here. I wish her nothing but the best, and I'm so sorry for what happened.
Ms. Arnold, anything on behalf of the people?
Oh, no, thank you.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. Ms. Adams, I do not have notice of right to appellate review.
Okay, sorry.
The criteria and the reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. These are the very worst of the cases that come in front of the court and that the attorneys have to represent anytime a life is lost. It affects everybody, but most importantly, the people who lost. And in this case, Mr. Dietos, you also lost a child due to your behavior, and the mother lost a child, and looks like she probably couldn't even come to me. So based on the fact she probably just can't deal with this either. Because I can see your client struggling as well, but I do see people in the courtroom, so I'm assuming her family members are here in support. And then Mr. Diego's family is here as well. Sentence of the court that you serve sentence with the Michigan Department of Corrections of 156 months to 600 months for the child abuse charge, and 4 years, 9 months to 15 years on the homicide charge. Those will be served concurrent. We have an updated credit.
Yes, 334 days.
Credit for 334 days. And I can order restitution here today.
Yes,
Okay,
I didn't have, oh, yes, I did, yes.
okay. I've just not had that before. Ms. Arnold, do you have any input on that? I've not had that happen before, and I'm sure Ms. Holly's right. I've never had restitution.
Yeah, I thought it was typically ordered as a condition of parole, but I don't think it's.
So what I'm going to do is I'm going to order $130 crime victim rights fee, $68 state costs, $60 DNA fee. As a condition of parole, you'll be required to pay $1,370 in restitution to the Michigan Department of Health and Human Services. There'll be a state supervision fee of $30 per month without monitor and $60 with monitor. And during, under the jurisdiction of the Michigan Department of Corrections, you'll obey and comply and complete all programming recommended. I know that for all the family members here, I mean, I lost a brother. There's nothing like the loss of a child. So I recognize how hard it is for everybody. And I'm sorry for everybody's loss. These cases just don't ever get better, and I'm sorry. So Mr. Dietos, you do have the right to appeal this sentence. My bailiff's going to hand down to you 3 copies of your notice of right to appellate review. I want you to initial and date 1 copy for my records. That's just to let me know that you received your paperwork. So go ahead and do that.
56, what she had checked, she found her. Yes, you would, was that 13 years you did? This year? She did.
So, yeah, Mr. Dietos, I didn't exceed the recommendation. So you sign that one just to acknowledge you received your appellate paperwork. If you decide that you want to appeal my sentence, you would fill out the information on that paperwork. You can do it today. You can do it and have it sent over by kite from the jail if you want, or you take it with you to the Michigan Department of Corrections, but you have 42 days. If you decide you want to appeal my sentence, you would fill out the information on the form and mail it to the address listed on the form within that 42 days, all right?
Okay.
Like I said, you can do that before you leave today if you want. I wish everybody healing and good luck in the future. Thank you.
Thank you. I'm talking here.
Oh.
All rise.
You guys weren't here in the criminal case. I'm like talking to them like they were members of the family. So you can be seated. All right, so Mr. Hotchkiss?
Yes, Your Honor.
Oh, there you are. You were hiding back there. I can't see over the monitor. And Mr. Trushon. So let me grab the file. All right, so do you need a bench conference with me before we start?
Yes, Your Honor, please.
Oh, okay, so let's go back to the jury room.
No,
How are you?
I'm good, how are you?
Still in the sense. It's all done.
156 is 671. Homicide is company, 4 years, 91 is 215.
Thanks.
Can they start again? Can you get me when they start again? Okay,
Okay,
I'm not gonna be right back, but.
okay.
I can look it up.
I have it down. I didn't have time. I haven't had time to make notes this time. Let me look it up for you.
All right, thank you.
I'll email this. Okay.
Oh, you can look at it. Right now.
Well, I mean,
You don't have to.
no, I don't. I'll just email it to you.
Okay.
Once I find it.
Yeah, that works. That's probably easier. So. So. What she's doing is. See what. So she said. She said. She said. She's like 60. She's out. That's one of the change. There is. She's just. No, that would be 600, 6,000. So I'm sorry. Yeah.
No.
Yes, that's what she is. She said, unless there's something that appraises that tells me that something's inaccurate, she said, I'm thinking 60,000. There's a lot. There's now that isn't really existing. It's where he gets his trash. Instead of that was purchasing, they had had some discussions apparently that was something. It wasn't, he was purchasing for about $1,500. So, introducing that, he said, I want to maintain it, trash services, and I said, well. We didn't have service. And said it was worth something. So I need to call that number because I'm not going to throw in extra. So he goes, okay, we have no appraisals on the property. He said, I'm going to put it back to me. It would be $5,000 down and awarding that on half. So basically, it's $62,000 total. So long we have to. And that's satisfying. So it is, so it was worth, hey, that's actually, yeah, $7,500 worth grabbing. So I think that, I'm gonna have to sit down just so that. True shot. But as soon as I do have that information, I will release you. I agree. Well, because the need is, yeah, X month is. So I guess in theory, but let's say that tomorrow. Yeah, so. Either way, too, if they're going to resolve it, or the alternative,
I didn't want to take it away.
As long as you want.
Well, that she did even say that. That's.
Correct, that's you, correct. That's you. I don't see that. Very easy. Well, absolutely. I'll say that.
She's already saying, no, it's not even gonna be the testimony of chicken.
It is. But.
And he's not gonna be that. No.
You're right.
You only be able to sleep.
Still on, if you want that, please.
I But he's like, the trial itself. Five. With, like, does not make sense, but then that would be this. So, let's. Social.
So I should do some.
Yes, sir. Perfect. Thank you.
Thank
So.
Nice to meet you.
Nature Nikita,
For me?
Nature Nikita.
Yeah, it does. Feels good though.
Whatever you just, yeah. Unless she'd like to, if she wants to try the case.
That's up to you. I'm over here.
There you go.
All right, I'll.
Are we it for the day for you?
I hope so.
You've had enough.
I have all these notes to put in and transcripts to work on, and I got all kinds of things to do, Mr. John.
Ah, there you go.
Very busy.
That's what the judge was saying. Yeah, yes, 2 days to claim. She's found 2022. You did, okay, good. Just want to make sure to cover that. We did. Sure. Well, I'm sorry. Say 2 years ago. Very quick.
Yeah, I don't care. That is valid.
Yeah, I mean, I was just gonna say former HO, and division of personal properties, take care of it, split up everything. What we split up, no spouse split forever, party. It might probably be 38 seconds. Do you want me to? I mean, I can.
All rise.
Seated. I thought you guys were like, ma'am, are you okay?
Yeah.
Okay. You were with Mr. Dietos, right?
Yes.
Did you need anything else?
Did I need anything else? No, thank you.
Okay, you're just hanging out?
Oh, is Chris done?
Mr. Dietos is done, yeah. He's been sentenced and he's done.
What did he get?
Um,
I'm
Yeah.
sorry, I missed something.
no, it's okay. We were here and, he, Miss Adams, what was the term of years I gave Mr. Dietos? I think he got 13 years to whatever the other end of the guidelines were.